Dear students, today we are going to discuss about the disputes mainly related to the TRIMS agreement. And TRIMS agreement, we saw that the agreement is mainly dealing with trade related investment measures. So, we saw the long list of trade related investment measures as well, and the most controversial and most discussed is the trade related investment measure is local content. Local content requirement imposed by members from time to time. So, we will see this class the WTO disputes mainly dealing with the local content requirement and what is the judgment of the panel and the appellate body. So, what is this local content requirement? The name itself says. So, some of the measures or some of the purchases, those companies, those who are working in India, or foreign companies, those who are working in India, or the collaboration companies, those who are working in India, and the government insists for purchase of certain products, certain spare parts, certain materials and certain equipments from the domestic market, and it may be dealing with the volume or it may be dealing with the value of the products, and this is the or you prescribe for a local production. This is in violation of GATT article 3(4). So, local content requirement. So, you ask the manufacturer to produce or to manufacturer to purchase certain quantity of the product or value of the product from the domestic market is against the GATT provisions or the new WTO agreement on trade related investment measures. And another which you can see the trade related investment measure is the trade balancing requirements. So, here also the measures taken requiring that a enterprise or a company or a manufacturer may be using, every company may be using imported products for manufacturing their product. It may be a car, it may be other products, and the measure stipulates that your import is limited to the amount of what you exports, and that is known as the trade balancing requirement. So, that the host country does not lose foreign exchange. This is also in violation of article 3(4) of the GATT. So, it means that it is relating to local production. So, it amounting to the volume and volume as well as value of local production to the exports. That means that also in violation of our GATT article 11(1), quantitative restrictions. You put quantitative restrictions, trade balancing measures, export import measures, you put local content measures. So, these are some of the trade related investment measures discussed in the WTO dispute settlement system, which we are going to see. Another restriction which we can see is the foreign exchange restrictions. So, here also the measure restricts the importation and exportation of or foreign exchange flows, inflows. So, we know that for example, India, the foreign exchange inflows are controlled by FEMA, the Foreign Exchange Management Act. So, if you put restrictions on the inflow of foreign exchange, that also is considered to be is in violation of GATT article 11(1). And other restriction is export restrictions or domestic sale requirements. As we know that in the most export processing zones, there can be 100% export export oriented units. So, here you prescribe that the manufacturer or the exporter should sell equal amount of products in the domestic market as well. So, they may be exporting at the same equal quantity, volume or value you sale requirement in the domestic market. This is also in violation of GATT article 11(1) quantitative restrictions. So, the TRIMS agreement very clearly says that is what are the areas, a set of trade related investment measures. And also we already discussed the TRIMS are connected with GATT's agreement as well, that is the General Agreement on Trade and Services, which we discussed about the 4 modes of supply, and the third mode of supply is commercial presence. So, here also you put this is a WTO GATT's agreed mode of service. So, this cannot be considered as a trade related investment measure, but if you violate, for example, if you deny the commercial presence, then it is going to be in violation of the GATT's agreement. And also the commercial presence and is subjected to mode 4 as well. So, you allow the commercial presence of a foreign firm or a foreign bank, but you do not allow the people to come and work here. So, you put restrictions on the movement of natural persons under mode 4, then again it is a violation of GATT's, and at the same time this is a foreign direct investment, whether it is coming to the service or it is coming to the financial institutions. So, then that will be in violation of the TRIPS agreement as well as the GATT's agreement. So, the service agreement as well. So, there is a connection between trade related investment measures and the services agreement, and here you can see a connectivity between the TRIPS agreement and TRIPS agreement. TRIPS agreement we are going to see in the next classes, next week classes, and trade related intellectual property. So, agreement, which you can see that. So, trade related aspects of intellectual property agreement also there is a connection. It says that we know that investment means foreign direct investment, and foreign direct investment is there is a lot of foreign direct investment in the pharmaceutical sector as well. So, the intellectual property protection is very important for all the FDI investors in the country. So, for example, China requires a Chinese law which requires transfer of technology to the Chinese counterpart within a period of 7 years. So, very recently many of the countries including the US take the China to the WTO dispute settlement system by saying that this particular provision is in violation of TRIPS agreement and GATT rules. So, you can see that you cannot prescribe, you cannot compel, you cannot stipulate any foreign direct investment or foreign investor to transfer the technology to the host country within a period of time. This is in violation of TRIPS agreement. Then the next agreement connection is the agreement on subsidies and countervailing measures agreement. So, this agreement we can see that when you export a subsidized good to a foreign country, then the foreign country have a right to impose additional taxes on such subsidized goods in your home country. So, it means if India subsidizing a product and it is sending or exporting that particular product in the another country and selling it for a lower price in the export market, then the importing country have a right to impose additional taxes to the tune of subsidies, that is the subsidies and countervailing measures. So, you can take countervailing measures against subsidies. So, there is a connection between subsidies agreement and the TRIPS agreement as well. So, when we come to the dispute settlement, and you can see that all the TRIPS related agreements are under the WTO DSU, that is the dispute settlement understanding agreement. So, all the dispute between member countries are going to be solved under this particular agreement. So, here you can see that this most of the foreign countries, we saw the origin of the TRIPS agreement. Most of the foreign countries, those who want protection for their foreign direct investment in other countries, they always try to enforce their rights if the other country, host country, is violating any of the TRIPS provisions. And so far you can see around 45 disputes came to the WTO dispute settlement until 2022. So, it is a sizable number of disputes, and TRIPS agreement is one of the now the fast growing disputed area, that means contentious area. It means that more and more countries are going for foreign direct investment, and so there the disputes, the number of disputes are also increasing. So, one point of time was 1995 when the WTO agreement came into force. So, many of the countries were forced to eliminate the trade related investment measures. So, there was a number of cases increased during that time, then now slowly again picking up the number of disputes. And we will see the some of these important cases from the TRIPS agreement. And one of the first such cases was the Indonesia automotive sector case. So, here the Indonesian automotive car policy requires the manufacturer to have local content. So, sourcing some of the parts from the local manufacturers and also lower sales tax, and subsidy issue was also involved. Definitely the local market and local manufacturers will be provided many kind of subsidies, and but now under the WTO, if you provide subsidy to the domestic producer, you have to give it to the foreigner as well. That means the people, those who are going to come to your country for investment, you have to provide that subsidy to them as well. There is no discrimination between foreigners and nationals, the national treatment principle, one of the cardinal principle of WTO. So, in the Indonesian autos case, the panel very clearly said that on the basis of, I quote, on the basis of our reading of these measures applied by Indonesia under the 1993 and 1996 car programs, which have investment objectives and investment features and which refers to investment programs, we find that these measures are aimed at encouraging the development of a local manufacturing capability for finished motor vehicles and parts and components in Indonesia. So, the panel very clearly said that the Indonesian automotive policy was against the WTO TRIPS agreement. So, these local content, of course, the only question decided was whether this local content requirement was related to trade related. So, here you know very well that the local content requirement, that sourcing parts of a car from the domestic market itself is nothing but a local content. So, and also providing subsidies to the domestic manufacturers. So, the panel said that this is inconsistent with article 3(4) national treatment principle and in violation of article 2(1) of the TRIPS agreement. So, it is not only inconsistent with the article 3(4) of the GATT as well as in violation of article 2(1) of the TRIPS agreement. So, similarly, you can see some more cases as well, the Easy Bananas 3 case. So, here the question was with regard to license. So, everybody knows that before 1995 the license Raj system was implemented in most of the countries including India. So, with the advent of the WTO in 1995, the license Raj system has abolished. So, here the measures, so the unreasonable license measures was held to be inconsistent with again article 3(4) and article 2 of the TRIPS agreement. So, it is very clear under the WTO regime, and you cannot put unreasonable restrictions on trade. and this is reiterated by the dispute settlement panels and appellate body through a series of cases. So, we saw the Indonesia automotive case, a similar case which you can find it in the Canada automotive sector case. So, the dispute was between the US and Canada. So, here also the Canada has so made it clear that it is a local content. So, here and the NAFTA agreement, that the North American Free Trade Agreement, one of the largest regional trade agreement between US and Canada. So, the local content requirement imposed by Canada was held to be in violation of a regional trade agreement. So, you cannot put the local content requirement neither under the WTO agreement nor under the regional trade agreements. So, the panel very clearly said that this is against the regional trade agreement as well. Now, we come to the automotive sector. So, in the automotive sector, India automotive case, it is similar to as that of Indonesia. So, we know that India there was few brands, or I would say that only one brand, that was the Ambassador, which was operating in India since the independence and till opening up of the Maruti manufacturing center in India. So, they have the monopoly. So, here the complainants were the United States and European Union, and which alleged the Indian violation of GATT article 3, 11 and 18B. So, here the 2000, the year 2000 itself, the complaint was filed by 2002, the reports were issued. And what was this case, which you can see that. So, the panel was established in both the cases, the US complaint as well as the EC complaint. So, the main complaint of these countries were that India has maintained, at that point of India had maintained number of restrictions, and the justification from India was that India faced a balance of payment problem in 1991, but you see that actually the India faced this balance of problem in 1991, but the cases were filed in 1998, but still they were taking shelter under the 1991 balance of payment problems, and which was not a valid argument at that point of time. So, here this case also is very clearly the panel found that. So, these are nothing to do with the balance of payment problems, and the Indian measures, the Act's restrictions on importation is contrary to article 11(1) quantitative restrictions, article 3(4) national treatment in violation. So, you cannot take shelter under the old balance of payment problem what is happened in 1991, and you cannot blame the balance of payment problem which has happened in 1991 for the actions after 6 or 7 years. So, finally, this after a prolonged litigation between the countries, and India has agreed to remove the restrictions with regard to the passenger car manufacturing in India, and entered into similar agreements with other countries like Australia, Canada, New Zealand, Switzerland, Japan, but India refused to enter into an agreement with the United States. So, but whether US is signing or not, once India implemented a single policy in India, it is applicable to all WTO members. Automatically it is applicable to all members. So, India lost the automotive case in panel and appellate body, and another case India was a party was India QR case, and here also India QR case, Indian quantitative restrictions case. So, India, this mainly the agriculture agreement was under question. So, India imposed quantitative restrictions on imports of agricultural goods and products, and imposed restrictions again based on the 1991 balance of payment problems. Here also the similar judgment was issued by the panel, and appellate body confirmed it. So, the Indian measures were in violation of article 11(1) quantitative restrictions and article 18B as well. So, it is not justified under article 18B, that is the balance of payment exceptions. exemptions. So, it is not justified. Again, India lost the QR case also. So, if you look into the Indian barriers to international trade, after 26, 27 years also India maintained barriers. I would say that India maintained barriers. So, even though India agreed to the WTO in 1995, when they signed the WTO agreement that we will eliminate all barriers, including quantitative restrictions, including license Raj system, including other barriers, but many times India was questioned before the panel and appellate body. So, here you can see that the auto component licensing policy was issued in 1997 by India. So, definitely this policy will be applicable to every country, every WTO member country, irrespective of they are operating in India or not operating in India. So, barriers become sometimes a great block for the import or trade with other countries. So, whether it is imposed by Canada or it is India, it is the same effect. And also indigenization policy is actually known as the local content. So, I always argue that, for example, now Indian industrial policy guideline says that Make in India program. I always argued that the Make in India program violates the TRIPS agreement, the provisions of the TRIPS agreement. So, the Make in India program, or you insist the manufacturers to manufacture the product in your country, is nothing but the violation of article 2(1) of the TRIPS agreement. This is nothing but indigenization, compulsion to indigenize. This is nothing but local content requirement. So, local content requirement is banned under the WTO agreements. So, now there are a lot of cases which we saw, that whether it is Indonesia auto case, India auto case, India QR case, and the US Canada auto case. So, we can see that the panel and appellate body many times very clearly held that indigenization requirement is against the GATT provisions and the TRIPS provisions as well. And trade balancing requirement, that export equal to import. So, whatever you export, equal amount should be the whatever you are importing, the value or the volume importing, you have to export. That is also in violation of article 3(4) of the GATT. And the trade balancing requirements, as I told you, that export restrictions on importation. Basically, this is nothing but because every country feels that more foreign direct investment will flow outwards rather than inwards. So, they were compelled to impose this particular restriction, and article 11(1), it is restrictions on importation. So, if you put any kind of restrictions, that is the balancing requirement, it is in violation of article 11(1) of the article 11(1) of the GATT agreement. So, in India prima facie failed to prove that it will come under these measures, will come under the exemptions under article 18(b), that is the balance of payment provisions. So, India lost, I think, almost all the cases, and even we will see that the solar case. The solar case is nothing but the India, there is a solar program which is run by the government of India under the name of Jawaharlal Nehru National Solar Mission. And here, so everybody knows that the people get some kind of subsidies for availing this particular program. For availing that particular subsidies, so you have to source certain products locally. So, you cannot use the completely imported products. So, the US compliant to the WTO dispute settlement system that this violates article 2(1) of the TRIPS agreement and other provisions of the, because here it is subsidized product. So, the article 3(1)(b), article 3(2), 5(c), 6(3)(a) and C and article 25 of subsidies and countervailing measures as well. The violation of two agreements, one is TRIPS agreement, other one is the subsidies agreement. So, the US complained to the panel, and the India so argued that So, this is there is a power purchase agreement, and there is a lot of conditions to participate in this particular program, and the solar modules. So, the solar modules and equipments, the developers had to sign an agreement, and the company as said that these kind of agreements insisting for localized products or the local content requirement is in violation of the TRIPS agreement, and the subsidies provided to companies, only those who comply with such conditions again violates the SCM agreement as well, the subsidies and countermeasures agreement as well. So, this is the case. So, as I told you, so India, so I have predicted that from the very beginning that India will lose this particular case, because India do not have any arguments, and India lost the case in 2016, and appeal also India went on appeal to the appellate body. So, India lost the appeal as well, because there is no point in appealing, and because the law, the jurisprudence is very clear, local content requirement is in violation of the TRIPS agreement. So, AB report, the appellate body report has mentioned about the Indonesia case, the Canada case, and other earlier its cases, and asked India to in conformity with the provisions of the TRIPS agreement as well as the SCM provisions. And so, you can see that, as I told you, the TRIPS, the trade related investment measures cannot be used as a tool of barrier in order to stop imports. So, local content requirement should not be used as a protectionist measure. In the renewable energy sector, everybody knows that the technology is with the developed countries, good technology is with the developed countries, and we also import large quantities of renewable energy, the solar panels from China as well. So, if the quality is very high, then the prices are going to be up. If it is not subsidized, then the people are going to purchase only the subsidized products. So, it is in violation of article 3 non discrimination principle. So, what happened? So, renewable energy sector. So, India filed another case against the US on the same point in 2017. So, we lost the case. So, immediately we filed a case against the US, and not surprisingly, India found that the US also adopted the same policies, and they are giving subsidized products, these programs in the state of Washington, California, Montana, Massachusetts, Connecticut, Michigan, Delaware and Minnesota. So, these states are providing subsidies in the solar program, and India filed a dispute in the WTO alleging the violations of article 3.4, article 16.1, 16.4 and other provisions of the subsidies agreement and article 2.1 of the TRIPS provisions. So, we lost the case, we filed a same case against the US, and we got a judgment from the panel, a similar decision from the panel, and the appeal is pending before the appellate body, because there is no appellate body presently to decide the appeal. But what happened? Nothing happened. So, US got a judgment against India, India got a judgment against the US. So, sometimes the dispute settlement is double edged sword. So, if you file against me and I can file against you, and both the countries got the judgment, and now both the countries are talking each other to resolve the problem. So, WTO dispute settlement system is very strong. So, every country have to comply with. So, TRIPS agreement is the one area where the number of disputes are increasing day by day, and the reason is many countries are going to other countries with foreign direct investment, and India is one of the country getting largest foreign direct investment in the recent times. So, this agreement is important for India, and also it is very important to remove all trade related investment measures, all barriers to trade within India, so that more and more foreign direct investment will flow to India, and which will help the Indian economy to grow very fast. So, I always argued that India is a protectionist country, and if you go with giving more and more incentives to the domestic industry, it is not going to be competitive, and that theory is proved to be correct immediately after the independence, whatever the policies which we followed until since independence to 1991. So, our economy is fastly growing only from after opening up of our markets, our economy, and not when it was a closed economy. So, going back to a closed economy is not a good idea, and that is bad for Indian economy in future. So, in conclusion, I would say that we should expect more number of TRIPS cases in the future, and we have to, in order to avoid this, and we have to remove all trade related investment measures from India, so that Indian economy can grow very fast. With this, I stop here about the TRIPS agreement. Thank you.